Okay, perfect. So I'm gonna get started to with introducing our wonderful speaker today. Thank you so much, everyone, for joining us. We'll be uploading also the presentation to our social media in case somebody couldn't make it today. Um, a brief introduction of Judith. She is our Assistant Dean and Director of the Legal Research Center, and she's also a professor of legal research. She holds a JD from USD Law and an MLLIS from the University of California. Prior to joining the library school, she was an attorney for the Department of the Navy's Office of General Counsel, practicing in the area of government contracts, employment law, and environmental law. Since joining USD, Judith has that advanced legal research, California civil practice research, and generative AI and legal research. So today's topic is going to be the impact of AI on the legal field, which I think it's a very popular topic nowadays. So Judith, you can go ahead and get started.
Okay, great. Well, welcome everyone, and thank you for joining us today. And thank you for that introduction, Barbara. So I'm going to share my screen right now, and so you can see the presentation. So hopefully you can all see that. Is that showing up, Barbara? Just want to make sure.
Yeah,
Okay, great.
perfect.
All right, great. And so what I'm going to do is, I'm going to be talking about a bunch of different things. But I think what I'll do is maybe about halfway through the presentation, I'll just kind of stop for a little bit and take a look at maybe some of the questions in the chat, and that might be just because I kind of divided it up into two sections, as you sort of see. So what I'm going to discuss today is just kind of like one of the, I guess, the biggest challenges or opportunities, depending on how you look at it, right, affecting the legal profession, which is the rise of generative AI tools. Okay. So this is kind of a roadmap for what we're going to cover today. And we have a diverse audience today. Some of you are attorneys, some of you are practicing outside the US, some of you are paralegals or legal assistants, law students. So before we dive into kind of today's topic, the heart of today's topic, which is how AI is affecting the practice of law and also legal education, which is what I work in, I want to spend some time just discussing how this technology actually works, right? AI literacy levels really vary tremendously within the students in my own classes and also among our faculty and the people who work at the law school. Some people use these tools every day, right? And others are just beginning to explore or dabble in them. But more importantly, kind of something I found is that most people, even many who may consider themselves to be power users, don't actually understand how these tools fundamentally work. And I kind of believe it's difficult to use these tools safely and effectively without understanding how generative AI technology is just fundamentally different from the technologies that have preceded it. Some people think of generative AI as just simply, a more advanced search engine, right? Or just, another form of the latest development in machine learning, right? But, and yeah, it is the latest development in machine learning, but it operates very differently from those that have come before it. And if you don't understand the nature of the technology, I think it becomes harder to understand both the strengths and the weaknesses, including why these systems hallucinate and why it's so difficult to stop them from hallucinating, and why verification remains so important in legal practice and in all uses of these tools. We also going to talk a little bit about the ethical and professional responsibilities of attorneys who are using these tools and how these tools are changing legal practice and also legal education, which is the topic of this presentation. So like I said, I want to talk a little bit about how generative AI works right now. But after this section, I think, if you want to throw some questions in the chat, we can take a look at those then. So just starting off, and for those of you who may have, advanced degrees in machine learning and computer science, just bear with me. I want to make sure I get everyone on the same page. I just want to define what a large language model or LLM is, right? And LLMs are basically, they're a type of generative AI, right? They're not search engines, they're not databases. They're defined as a type of artificial intelligence model that has been trained through deep learning algorithms to recognize, generate, translate, and or summarize vast quantities of written human language and textual data. Okay, so that's a mouthful. What does this mean? What is a deep learning algorithm, to begin with? Just think of it this way. A language model at its simplest is just a collection of vectors, right? And a vector is like an arrow that shows direction and distance, and it has infinite options from which to choose. So an LLM uses millions of dimensions, millions of words and vectors, and basically plays this giant game of matching and probability. So at its simplest, you could say it's basically guessing of what the next word should be. And that's why it's called generative AI technology, right? It's figuring out what the next word that should be generated should be. And this is a really simplistic explanation for what vector space is. And for those of you who are interested in getting a more in-depth, yet very accessible explanation about neural nets, about transformer technology, check out the neural networks series on 3 Blue and 1 Brown. I think a lot of you may already be familiar with this. This is something that pretty much everyone in math and computer and machine learning and science is familiar with. It's basically an educational YouTube channel that focuses on teaching higher level math from a visual perspective. It's run by a mathematician who got his math degree from Stanford, who worked for the Khan Academy, producing videos for them, and who now runs this channel full time. And they're incredibly well done. But what I'm going to do right now is just kind of give you an example of what it looks like for an LLM to learn how to predict text. So kind of like transformer technology in a nutshell. But again, if you want a more in-depth explanation, take a look at 3 Blue and 1 Brown. So let's just say we have this sentence, right? It says, this is something that is given to the LLM to train. And it says the man went to the store to get a gallon of something for his cereal. And the LLM has to guess or figure out what goes in there. So the first time, so you're thinking everyone's going to look at it and say, oh yeah, it's milk, right? I mean, that's what it is. So the first time that an LLM plays this game, when it's being trained, it might guess, who knows? It might say the word elephant, or whatever, right at the beginning, or vodka, or whatever. But through a combination of self-reflection and a lot of human guidance, it eventually learns that the response that's most likely expected is milk, and remembers that vector choice. So how does it do this? Well, it uses something called transformer technology to parallel process the entire sentence. So older AI models would basically read text one word at a time, but a transformer processes the entire sentence all at once. So first what it does, it basically kind of breaks the sentence up into tokens, right? And so these are the tokens right up here. And really, when you're looking at a token could be a word, it could be a punctuation mark, it could be parts of a word. But for just the sake of simplicity, I'm just going to say a token is just a word or a punctuation mark. And you can see how they're divided up in this sentence. And then each token is assigned a weight in vector space. And it uses something called self-attention to determine the context of the words to adjust the weights or the parameter of each word. So self-attention kind of has each token talk to each other and figure out context, right? So it's figuring out word orders. So each word kind of looks around and says, okay, is there a word that comes before me? Is there a word that comes after me? Where am I in the sentence? Am I a noun? Am I an adjective? Am I modifying another word? Am I being modified? All of this is important. And it also kind of figures out different meanings of the words. For example, the word store has different meanings, right? You have the verb to store something, but then you also have the store, the noun, where you buy something, right? So it figures out that through the transformer layers, eventually, that this is a store where you buy something. And it'll adjust those vectors or weights as it goes through multiple layers of self-attention. And then there's also something called attention heads that capture different clues. So they look at signals like grammar. So we have gallon of, like we have, went to the store to gallon of something. So normally that blank, if you're looking at it, you're kind of figuring out, oh, it's a noun, right? And gallon usually signifies a liquid. So we're looking for a noun that's some kind of liquid. And attention heads might also look at semantic fit and say, the words cereal, store, and gallon are often statistically correlated with the word milk. And so as the sentence moves through multiple transformer layers, unlikely word options are gradually suppressed, their weights go down, and more likely tokens get weighed more heavily until you finally get to the final layer where the word milk has the highest weight compared to other options like orange juice or coffee or soy milk, which those words themselves would be weighed more heavily than things like vodka or gin or wine, right? And those would be weighed more heavily than pink. Now, its powerful algorithms and ability to mimic human language can give the appearance of knowledge and understanding. So people say, oh, it knows the prompt calls for milk. But it truly can't know the answer is milk and not something more specific, like oat milk or almond milk, or maybe like vodka, right? It just depends on what the training was like. It's also worth pointing out that an LLM will present its answer with a lot of confidence, even though it can't truly know that it's correct. So with that understanding of the basics of how LLMs and generative AI tools work, we can see how they can really be helpful to the research and writing process. For lawyers, since their strength lies in their ability to kind of generate coherent text based on defined concepts. Because after all, they are in essence word generators. They also have a really strong ability to recognize patterns, which makes them extremely good at searching for related concepts. So these tools can be good at describing a legal rule or a test if it has a lot of cases describing that rule in its training data. So you can see how that would be helpful for legal research, right? And they can also help in editing your writing. They can identify typos, grammar mistakes. They're a step above things like spell check and Grammarly, in that they can do things like rephrase or change their tone to provide different examples of a sentence for different audiences. They're also really good at summarizing, right? So they can be a huge time saver in this sense. In this sense. However, if you look at the weaknesses, their inability to distinguish whether that readable text is factually true or not is a weakness of LLMs. Because LLMs were built for language fluency and not factual accuracy. So this makes them prone to that ultimate hallucination. So you always need to verify the output in the analysis. Also remember that LLMs are trained on different data sets, right? So you always have to look, how current is the training data? There's different cutoff dates between tools. For example, for those of you who maybe enjoy using Claude Sonnet, 4.6 was released in February, right? But the actual reliable training data cutoff was in August, right? And so what that means is that if a case came out since August, it won't have been in the training data. Now, these tools have advanced since they first came out. And so they have web searching capabilities. You can always upload a document. So there's ways for you to get it to analyze the case. But just remembering that, if it wasn't in the training data, then it'll be farther away from its training distribution, which means it's more likely to hiccup or make hallucinations. And we'll talk about that in just a little bit. And then there's also intentional limitations on scope. For example, there's what Westlaw and Lexis. Okay, so Westlaw, for those of you who aren't familiar with these, Westlaw and Lexis are the legal research databases that attorneys use here in the US. And they contain things like primary sources, like cases, codes, court rules, all agency decisions, and they also have secondary sources like legal encyclopedias, books, how-to books, and how to practice guides that are geared for attorneys that have forms in them. Also, law review articles for scholars. That's all in those databases. So if you're using something like Lexis, if you're using the AI tools that are available in Westlaw and Lexis, you're probably not going to. You have to remember they're trained on what's in those databases. They're not trained on like food blogs. So you wouldn't get chocolate chip cookie recipes, right? So that's like a really simple explanation. But more to the point, many people think that when they're using the AI tools in Lexis or Westlaw, that the scope of the training data will include everything in Lexis or Westlaw. But that's not the case at all. The training data basically includes the primary source material. So all the cases, the codes, all of that are in the training data. But it's only select secondary sources. So not all the practice guides are in there. Westlaw just included all their rudder guides, which are like kind of like the gold standard practice guides that attorneys in California and Texas use. But before that, they weren't in there, and they're slowly adding those. But one of the things is that law review articles are not included in there at all. And so that's why our scholars, our faculty usually don't use the AI tools in Westlaw because they need to be able to access those law review articles. And so this is what you always have to do. You always have to look and see what is the scope of the training data in this item that I'm using. How current is it? You also have to take a look at the inherent bias in these systems, right? If there's bias in the training data, then there's going to be bias in the output also. So you always have to kind of pay attention to that. And then there's also confidentiality issues. Most LLMs were trained are using industry standards, right? So there's some assurance of confidentiality when entering personal information. But legal practitioners should never enter confidential client information without first checking the data privacy protections, right? And that's also included in the rules of conduct for attorneys. And we'll talk about that in just a few minutes. Tools like Lexis and Westlaw offer stronger confidentiality protections, but firms often have different thoughts about it, and they might not be comfortable with those things. I mean, some of their clients have trade secrets, patents. They might be in government, are also very, very concerned about these things. And so that's why some firms are developing their own in-house tools, right? They're making their own custom tools, contracting with OpenAI, with an assurance that their tools The tools will never use their data for training purposes. And then perhaps one of the biggest weaknesses of these LLMs is that they tend to produce content with a level of confidence that's not really commensurate to the level of accuracy that they produce, right? And this level of confidence can really vary between tools. And tools designed for the legal market, like the tools that are available in Lexis and Westlaw or Harvey or Vincent, all those Legora, these other tools, will often tend to give more warnings, right? They'll be guardrails. So if a user asks a question that can't be answered using that database or that tool, it'll say, I can't answer that question, right? They'll say that. Claude is another tool, even though that's a general LLM. That one actually has a lot more guardrails, and it will refuse to often answer questions, especially if you ask for things that are not within its scope of training. Other tools like Gemini, for example, will answer any question that you ask it, even if it shouldn't. And so it can really kind of go off the rails. So they just kind of, they just vary from that. So that's kind of how general LLMs work. There's also something called retrieval augmented generation, or RAG. And this is something that I just feel like is like so important for people to know. Like because if you're an attorney and you're using something like Lexis and Westlaw, or you're trying to decide whether to use Lexis and Westlaw, or if you want to use ChatGPT, you really need to know what the benefits and risks are of using a general LLM as opposed to a RAG. So basically, a RAG is a technique that combines traditional information retrieval systems with large language models to improve their accuracy. So the AI tools that are available in Lexis Protege, or Westlaw's AI-assisted research are RAGs, which means that what they do is they combine their more traditional search algorithms that they've always had in their databases, and they use those. So when a user enters a prompt, it'll first use in Lexis. Lexis will first use its traditional search algorithm to first retrieve relevant documents from its own database to answer the user's prompt, right? And searching just the contents of its database, not stuff on the web or anything like that, just what's in there. And then it provides those documents to the AI tool that's in there and lets it do its AI magic. And what this does is it does help to reduce hallucinations, because basically, you at least know that Lexis is retrieving real documents. So you're not going to have cases where it's fabricating a site and then fabricating a citation that goes along with it, right? And so it will, but something to keep in mind is that the AI tool is still a generative AI tool, right? And so it can still hallucinate in a different way and give you highly inaccurate information, right? So verification is still a key step, and I'll explain that in just a sec. Because so what about hallucinations, right? When you're using these Lexis and Westlaw products, which use RAG, or retrieval augmented generation, are you still running the risk of hallucination? Well, it kind of depends on how you define a hallucination. So Lexis and Westlaw have claimed that RAG eliminates hallucinations because RAG works by having the system, like I said, first identify relevant documents, real relevant documents, and then running the AI tool on those documents. So they define a hallucination as citing to a non-existent case, right? All the news articles that you're hearing about attorneys getting into trouble, that's what they're talking about. They're citing to a case that didn't exist. When the judge looks up the citation, there's like, oh, there's nothing here by that site, and then they get into trouble. So yeah, if you define a hallucination that narrowly as cases where the AI tool just kind of fabricates documents, then RAG, which Lexis and Westlaw use, will pretty much eliminate that risk, right? Because they're pulling up real documents and then giving it to the AI tool. But if you define hallucinations a little more broadly by including situations where the tool's answer to someone's answer to a user prompt is just plain incorrect or misgrounded, then they can still hallucinate. And just an example, an incorrect answer would be, let's just say you ask a question of Lexis, and Lexis responds by saying, you know what, there is no right to same-sex marriage in the United States based on the Supreme Court case Obergefell versus Hodges, and it gives you that case, right? And then the user reads the case and they say, well, this is interesting because in fact, Obergefell held that the right to same-sex marriage is protected under the U.S. Constitution, and it's actually the Supreme Court case that established that right. So stating the exact opposite of what the holding actually is would be an incorrect answer, but it wouldn't be necessarily considered a hallucination by Lexis or Westlaw, because they would say, well, Obergefell is actually a real case. It's actually the on-point case. It maybe flubbed in analyzing it, but at least it gave you the right case. So it's not a hallucination. A misgrounded answer to a prompt would be where there's a correct answer, but it cites to the wrong sources. So an example would be you use Lexis or Westlaw. It gives you an answer saying, you know what, this time it says the right to same-sex marriage is protected under the US Constitution, right? So that's correct. But instead of citing to Obergefell, or maybe even another case that has to do with same-sex marriage, it cites to Miranda versus Arizona. So for those of you who are not familiar with U.S. law, Miranda versus Arizona is kind of like the seminal case that requires police give a Miranda warning. Basically, if you arrest someone, you have to say you have the right to remain silent. You have a right to an attorney. And so it's totally unrelated. So again, Lexis and Westlaw would say, well, yeah, it's not related to same-sex marriage, but Miranda versus Arizona is a real case, right? And but you know what? Incorrect and misgrounded answers are pretty bad, right? And one could argue that they're even worse than fabricated cases because they're harder to spot. So the examples that I gave came from this article, Hallucination Free, Assessing the Reliability of Leading AI Legal Research Tools. And so after this, if you're interested, we can email you this slide deck, because I do have some hyperlinks in here to some of the studies, some articles that you might be interested, if you want to do some more work on your own. And basically this was written by researchers at Stanford's Reg Lab and their Institute for Human-Centered AI. And what they did was they ran hundreds of legal research prompts through ChatGPT and also Lexis's and Westlaw's AI tools, and found that both Lexis and Westlaw's AI tools hallucinated. If you define hallucination as providing incorrect or misgrounded answers rather than outright fabricated cases, right? And it's a widely cited article in this area, so it's really worth the read. So right now, before I kind of go on, actually, no, let me just do one more example, and then I'll take some questions if there are any. So I've been talking a lot about hallucinations, right? And I just kind of want to give you an example that really highlights how they can happen. And hopefully this will make you a little bit more nervous when you're using these AI tools. And if you haven't been verifying diligently, hopefully this will make you do that. So this is an example of chain of thought prompting, right? And so this is where the user asks the chatbot to break its reasoning down into steps rather than making a huge inferential leap. So rather than just saying, here's my question, provide an answer, it asks you to break it down into steps, right? And what it is it's the idea is that it helps the model avoid incorrect shortcuts by breaking the task down into discrete steps to improve accuracy. And the idea is it should hopefully reduce hallucinations caused by the system making these kind of incorrect global inferences and just skipping steps. It also allows the human user to observe and correct the AI's thinking at each step. So here we have the user, right, asking a question of Gemini. And the article kind of goes, there's an article in here. Oh, no, it was kind of cut off at the bottom, but it is in my slide deck. So if you want to take a look at that, you can read the study in full. What it does is it asks the user to use chain of thought prompting to answer the question, was the US established in a leap year or a normal year, right? So rather than just saying yes or no, or just saying leap year or normal year, it actually has to explain its steps. And so if you say, please use chain of thought prompting, these LLMs will understand what you're saying, and they will actually automatically do it. But you could also lay out the steps if you wanted to do it. So you could say, in this case, you could say, first determine what year the US was established, provide that answer, right? And then you could say, determine if that number, that year, is divisible by 4, and just say yes or no. And then determine if it's a century year, right? So a century year is like 1700, 1800, 2000, something that ends in 00. And then if it's a normal year, then you say it is a leap year. And if it's a century year, then you would say it's a normal year, and then provide the final answer. Okay. So so just take a look at this and just see what happened. I'll just give you a second to read through this. You can read through that. So it basically flubbed, right? If you look up here, Gemini responded and said that US was established in 1776. So that's correct. It determined what year it was. It figured out if it was divisible by 4, said yes, it is. And then it said it is not a century year, right? So then it is a leap year. And this is totally correct. But then when it gave the final answer, it says, therefore, the day the US was established was in a normal year. So what happened here? It just basically, and so this is kind of what LLMs do. They can produce reasoning steps that are just beautifully structured. Like you read them and you're like, oh, this is wonderful. It's really a guy going through this step by step. But remember, these things were built for language fluency and not factual accuracy, right? So it's not logically sound. They might look like they're reasoning, but they're actually not. These things are not capable of reasoning. What they're doing is they're just imitating reasoning patterns that they saw in the training data, right? So this example shows this is pattern replication, not genuine inference making on the part of the system, right? So the thing to keep in mind is that even chain of thought prompting, which is supposed to improve LLM performance, while it's helpful, right? Because here the user can spot the error and see, oh yeah, if they had just asked it to give an answer, you would never know. You would have to figure it out yourself. So basically, but it still breaks down, right? When you push these systems beyond their training distributions. And the training distribution is a range of examples, patterns, and situations that an AI model was exposed to while it's being trained. So the closer the user's prompts are to the training examples, the better it's going to perform. And the further the prompt falls outside of the training, the less reliable it'll be. So in this case, Gemini was probably not trained on these types of questions, right? He had to figure out on his own, and it just kind of figures out from their pattern. So before so I just kind of want to get that out there, and then I really want to turn to sort of the ethical responsibility for attorneys. But I just want to know right now, are there any questions that people have? You see any questions? I have it right now because I'm sharing my screen. I can't see if there's any questions in the chat. But do you see anything, Barbara?
I currently don't see any questions in the chat. As you did mention, feel free to put your questions in writing, or as well, if you have any questions at the end, we can address them.
Okay. So I'll just keep going then.
Thank you.
See how much time we have. Okay, so we're good. So now that we've covered the nature of the nature of these tools kind of make them prone to hallucinations, I'm going to talk about why attorneys and the people they supervise should still use them, right? And one of the things I just kind of want to mention this, I want to make sure I have enough time, so I'm going to kind of skim through this, is that, they create huge efficiencies, right? Which is why law firms are all about them. Because if you think about it, I mean, these things have the ability to kind of really hallucinate badly, right? So some people might just think it's just not worth the risk. Or you might have attorneys who basically say, you know what, I've been doing insurance defense or real estate law, whatever, for like 20 years. I know everything I need to know about this. I have my tools, I have my methods. Why should I learn this new technology that has the potential for all this risk, right? And but basically so there's a couple of reasons, right? And the first one is that they create huge efficiency. So this is a presentation from a person who trained new attorneys at Melvin and Myers, which is a big firm in town. And they said a couple of things that are worth paying attention to. First, they say generative AI is useful, but it's only one tool in an attorney's toolbox. So they want students to be able to use these tools, but they also want them to know how to do research the traditional way, right? Because you're not going to be able to assess the results, verify the results, unless you know how to do the work in the first place, right? But secondly, that being said, they really want new hires to come in at least this AI 101 level over here, which is where they learn, they understand the risks, the benefits, they understand the basic terminology, what's a RAG, what's an LLM, that type of thing. But then they say a lot of people are coming in at the 201, 202 level. And I have to say, this presentation was done like a year ago. So things have changed. I'd say right now, they're really expecting people to come in at a higher level at this point. And at the 201 level, you have people who can do a good prompt, who have a good idea of how to use it for research. And at the 202 level, you have people who are able to use it for ideation, brainstorming, kind of higher level works, right? But then here at the 301 level, right over here, you have people who can think of new uses for AI in the work of the firm, right? They're the innovators, the ones who can think of better ways to save time and get better results. They're the ones who have enough facility with these tools that they're well positioned to talk to clients and to vendors, right? And so basically, like I said, I was asking, why should an attorney feel like they have to use these tools if they don't want to? Well, a lot of times there might be some firms who are holding back. They're like, I don't really want to use these tools right now, but the clients are pushing them because they don't want to pay for an attorney who they feel like, why should I pay for an attorney when an AI can do this faster? They also don't want to. They also want to know why they're billing for an associate to do hours and hours of work when an AI can just do the work in just a few seconds. And so the firm needs people who can explain to clients how AI is being used or not used, right? How safe, if it's being used, how safeguards are in place to avoid hallucinations, how it's saving them money, how there's confidentiality protections in there. If they're not using it, they have to explain why, in this case, it's not appropriate for an AI to do this. Maybe because of confidentiality issues, or just because the judgment of a human attorney is just called for in this situation, right? The 301 people are also the ones who can deal with the vendors and help guide the firm in tool selection, how to set usage policies, that type of thing. So at USD here, our goal is to kind of get students as close as possible to that 301 level before they graduate. But of course, if that wasn't enough reason, attorneys are also ethically and professionally required to learn about these tools, right? So we have the American Bar Association, which writes the model rules of professional conduct for all the states. And then we have the State Bar of California, which actually adopts and enforces the actual disciplinary rules in our states. And both require attorneys to understand the technologies available to them as a lawyer. And that the technologies definitely include generative AI technologies. Okay. And so when an attorney is being disciplined, right, they're being sanctioned, they're going to be fined or they're going to be disbarred, it would be done under the California State Bar rules, which are patterned after the model rules. So basically, this duty to learn about these technologies isn't optional anymore. It's an ethical obligation. So basically ABA Formal Opinion 512 up here. So these are the ABA, that's the ABA discussion of generative AI, which you're welcome to take a look at later, basically says that ABA Model Rule 1.1, which is the one that requires that attorneys be competent and provide competent representation, say that now that the competence requirement now includes understanding the benefits and risks associated with relevant technology, which means that if an attorney doesn't want to use AI, they have to at least know enough about generative AI to know that it's acceptable for them to not use it in that particular situation. So they can't just stick their head in the sand. And the California Bar has echoed this expectation in its own guidance, right? More importantly, if an attorney does use generative AI output, the rules say that attorneys have to verify those outputs, right? And that they are fully responsible for anything they submit to a court or to a client. And the California Rules of Court also reiterate that duty to verify outputs and submit accurate information to the courts, right? The guidance in the Rules of Court also go on to say that attorneys have to protect client information. They have to, so they basically, before entering information into something like ChatGPT or whatever, they have to first check to see what the data protection standards are, right? And if it's something like ChatGPT that may use the information in their own training data, then they have to get they have to communicate that to clients and get their permission. They also have to make sure that the attorneys they supervise, the paralegals they supervise, the third-party agents who might be acting for them are also using these tools accurately. And basically, the rules require that you are candid with the tribunal. You cannot lie to a court, and putting in a fake citation is lying to the court, right? So that's all that. They also have to charge reasonable fees, right? So they can't charge, 10 hours when they answered a question in 5 minutes, because they now have an AI tools. So that's kind of something that they have to look at. So what happens if you don't follow the rules? Well, you end up in a news story. So these are a couple of stories that you might want to take a look at later. The first article is from our local newspaper, San Diego Union Tribune, right here. And it just came out last April. So it's really recent. And this is one where an Oregon judge ordered a San Diego attorney to pay nearly $100,000. It was 96 grand in penalties for submitting briefs in a lawsuit that contained more than 20 non-existent legal citations that were all hallucinated by generative AI. Basically, courts are really losing patience, and they come down really hard on attorneys who use generative AI ineffectively. Okay, judges don't mind if people use AI. Okay, they just want them to use them responsibly, and because judges are using AI themselves, but you have to verify your sites, and if you're sloppy about it, they will come down hard on you. Everyone makes mistakes, right? And courts understand that, but if you make a mistake, like you've missed a deadline, or you copy something incorrectly, or whatever it is, a lot of times they will give you leeway, they'll let you amend. But when it comes with putting in a hallucinated citation, they often have zero tolerance. There are other cases out there where the judge has just dismissed lawsuits because of this, and that really harms the client, right? And also opens up a malpractice suit. So there's zero tolerance. Judges are also getting into trouble. Last summer, a couple of federal court judges, one in, I think it was Mississippi, and another one in New Jersey, both had to withdraw opinions that contained errors due to the use of generative AI tools. So in a lot of times what happens is a court will copy text from the pleadings, right? And so a lot of times maybe one of the parties used generative AI has a fake site in there, and the court would be sloppy and just copy that language from the pleadings and put it into their order. So that's bad. That's not something that they're not supposed to do, but that's just sloppiness, right? In this case, in these two cases, it was clear that the judges or the people working for the judges were using AI tools and had used them ineffectively because they were citing to like non-existent parties, non-existent allegations, stuff that just wasn't in the pleadings at all. So it was clear that someone in the court had misused AI. And so they kind of try to fluff it off. The judges fluffed it off by, blaming the clerks who weren't working there anymore. They said, oh, someone just didn't check this properly. But one of our senators, Senator Grassley of the U.S. Senate Judiciary Committee, called them out in writing by writing to them publicly. He also wrote to the Administrative Office of the Courts, and they had to publicly apologize and then come up with procedures to ensure that this wouldn't happen again. So it was a public shame, right? And so basically, this is something. So basically, we teach our students how to use AI both ethically, so they're not going to end up in the evening news or in one of these news stories. And we also want to teach them effectively so they can get hired. Okay. So how is AI affecting legal practice? Well, one of the things it's doing is it's really disrupting the uh, one of the most important stages of attorney education, which is the transition from law school to practice, right? So historically, attorneys were trained. So I'm talking like back in the 1700s, basically up until the late 1800s, attorneys were usually trained through apprenticeships, right? People who wanted to become a lawyer would find an experienced attorney and say, "Hey, can I apprentice under you?" And so the experienced attorney would take them along to court, let them observe court proceedings, let them watch them cross-examine someone. They'll start them off by letting them copy legal documents and increasingly take on more complex tasks, right? So they would, write memoranda. They would, write legal documents. They would observe them. They would give them readings. And then after a few years, they're like, okay, you can go on and practice on your own. Well, in the late 19th century, that changed with the Langdalian method in Harvard, right? And that's the method for those of you who went to U.S. law schools. For those of you who are law students now, that's the Socratic method, right? You read appellate cases, and then you're questioned through the Socratic method. And this method allowed law schools to educate a large number of students at once, rather than relying on one-on-one apprenticeships. And so this is nice. The Langdalian method is nice if you want to teach students to think like a lawyer, analyze cases, identify legal principles, but it's not so great about teaching students how to practice law, right? How to conduct yourself in court, how to interact with clients, how to take a deposition, how to question witnesses or prepare legal documents. And so law schools offer clinical courses and practical skills courses to help bridge this gap. But most attorneys would say that they really didn't learn how to practice until they started practicing at their first job, right? And traditionally, law firms played this really major role in this final stage of training, right? It was an unofficial thing, but it was in an important stage. So, like summer associates or new hires would be, they would get hired and they were treated, they're kind of treated like slaves, right? They're expected to work really long hours and toil and do all of this work, but they're getting a huge benefit, right? They're getting on the job training and mentorship. But firms are balking at this arrangement. And even before generative AI, clients and firms were pulling back from subsidizing this aspect of attorney education. Clients didn't want to be billed for extra hours to have this inexperienced junior associate take 3 times as long to complete a task as an experienced attorney would take. And AI is really accelerating this shift by increasingly automating tasks like first pass research, document review, contract analysis, due diligence, that type of thing, right? So this means that junior attorneys will increasingly be expected to not merely produce work product, but they're expected to supervise these AI systems, right? To be able to evaluate AI output. And the challenge is that these types of skills kind of come with experience, right? And so a lot of times hiring attorneys complain that new hires often don't have the experience or the judgment to effectively evaluate AI outputs. And it's easier for them to do it themselves, right? And so they'd rather just use the AI tool themselves rather than having the junior associate use an AI tool and then having to check their work to make sure that to verify it. So there's a fear that attorneys are just going to start hiring more laterals rather than junior associates. But then people have to learn somewhere, right? And eventually you're going to run out of laterals. Another thing where it's affecting it is through billing, right? The billable hour. Since AI can reduce the time it takes to complete legal tasks from hours or even days to just minutes, clients expect lower bills, right? And as I mentioned, clients are often the ones who are pushing firms to adopting AI tools because they want reduced costs. And they also feel that it might produce better results, even though it may not. It just depends on how good people are at using them. And so some firms may move towards more alternative fee arrangements or fixed fee services rather than purely hourly billings, right? I think people are hopeful the legal costs are going to come down, but in all, what's probably going to happen is that, you know, what firms will say is that, you know, AI driven efficiency will allow firms to kind of redirect the time that attorneys are taking towards higher value strategic work, right? So they're basically saying, well, they're spending less time parsing through a case file. So now they can spend more time just like strategizing, maybe going out and talking to more witnesses. There's more. And so most likely it's not going to bring costs down that much, except in one area, which is in the access to justice. And I want to make sure I have some time for questions in here because I'm at 4:43. So I just want to pause for a second and see, do we have any questions or can I?
Yes, I see that we have some questions in the chat.
Mhm.
The first one is from Val. She has two questions. The first one is that her firm is using Parley, and she's curious if you're familiar with this software.
Uh-huh.
And she's also curious to see how would it impact when you are uploading sensitive client information for analysis within an AI platform that a
Okay.
law firm might be cooperating with.
So you said Harvey, right?
Parley.
Harley?
Yes, I see
Okay.
here Parley.
Okay. Okay. I We have not used Parley. We use Harvey, which is another one. And there's a bunch of different tools out there. There's like Harvey, there's Legora, there's Vincent AI, which is part of VLEX, and I assume Parley kind of works the same way with those. I think it's just so. Is she asking about like a confidentiality issues with that, with uploading the documents, or?
Yes, she's curious if by uploading, it looks like sensitive client information like documents to maybe start a first draft of a motion or maybe a declaration. Like I'm guessing she's trying to see the attorney-client privilege.
Mhm. Yeah. So it really depends on the data protection standards that are in Parley. Okay. So basically your firm should probably give you guidelines on how to use it. But at the very least, I guess you should take a look at all these systems will have data protection standards. And so if you're looking at like something like Harvey or Vincent, they all have little disclaimers in there that basically promise that they won't use your data for training purposes. Right. And that's super important. You also want to make sure that it's a system that you trust. Now, if this is something that's condoned by your firm, I'm assuming it's gone through the vetting process, right? If it's something that you're using on your own, then I would be a little bit more careful, and I would go back and basically check with with the firm's policies of what you can use, because there are some firms that are basically just saying you can't use ChatGPT or you can't use any of these third-party things. Some of them don't even want to use Lexis and Westlaw, which I think is a little bit of overkill because I feel very safe using things in Lexis and Westlaw. Now, but again, it just depends on your firm. So if this is something that's condoned by your firm, hopefully it's been vetted. I would talk to whoever manages that in your firm. If it's something that's third party, I would really take a look at the data protection standards and make sure that it really keeps it safe. Because yes, there have been some cases that have come out recently that have said that if you enter something into Chat GPT, right, and that is a general LLM that is open to the public, and they're very clear that your stuff will be used in the training data. They say that can waive attorney-client privilege, right? And so, and that's a scary thing. I suspect that case is going to get reversed. That was a case that just came out. I suspect it's going to go up on appeal. It better go up on appeal, and it may get reversed. But that would be a really scary precedent to just basically say by using this tool that you waive attorney-client privilege. But there are cases that say that, so I would be really really careful about that, and just check with your firm. That's what I always say: check with your firm.
Thank you, Judith. Val, I hope that answers your question. And then we have a question from Sydney Johnson. She's asking who is responsible if an AI generated legal output is wrong or misleading?
The attorney. The attorney is responsible. The attorney is always responsible. The person who submits that thing. So it's basically, it's you can't blame the tool. I mean, you can. I mean, you can't blame the tool. You can't blame the paralegal who used the tool. You can't blame the junior associate who tool. I mean, all of those would be liable, right? So because if you look at the bar rules, it basically says that supervising attorneys, right? So if you delegate a task to someone below you to do something, and they use the AI tool, you are responsible for their work, right? The attorney, the junior associate who also did that work is also responsible. So all those people could be disciplined under the rules, right? But basically, when you submit, it is the duty of the attorney to make sure that everything that they file with the court or send to the client, like if they're sending a memorandum to the client, that's another thing also, that everything in there is factually accurate. So if you use an AI tool, you have to verify everything that's in there to make sure. And if you feel like you don't have the time to do that, then you should write with the tool. Yeah, but basically, the attorney is responsible.
Thank you, Judith. And then we have another question in the chat. She's asking, to what extent can AI interpret legal gaps or ambiguities within a complex legal operational interface in a context-sensitive manner without being constrained by reliance on historical patterns?
Well, I'm gonna have to let me take a look at that. That was a long question. Let me take a look and see. Let me take
Of course, I think it's in the chat for everyone.
okay. That partly too.
I guess the main question will be what I'm interpreting is to what extent can AI interpret legal gaps or
Yeah,
ambiguities?
they're really good for that type of thing. You know what I mean? I mean, because so I'm going to try to to figure out exactly what you're saying here. That is actually a good use for AI tools because one of the things that people will use them for is what I like to do, or what a lot of people like to do, is like they'll write something, right? They'll write their memorandum, they'll write their analysis or whatever it is. And then you can give it to the tool and just say, did I miss something in here? Am I missing something in here? Or you can just say, there's an ambiguity here, right? Can you find cases that kind of go on either side of all of these? And that I think you can do that. But you're also asking about historical patterns. And that is an issue with it, right? Because whatever is in the training data is going to constrain it. Now, if you're using a tool like Westlaw or Lexis, I feel like there's less of an issue with the historical patterns. I mean, like all the case law that came prior to it is going to show up, right? But then when you're doing legal research, you probably want those things to kind of show up in there. But one of the things that this kind of brings up the issue of bias, right? Because that's the whole thing. When you're dealing with like new areas of law, right? Like let's just say maybe you're looking at like certain types of civil rights actions that maybe didn't exist 20 years ago. That's where the AI might kind of not be as robust because that's not going to be as much in the training data, right? And so, because it's going to be looking at older cases and seeing how older cases interpret these things. And so, if there's not a lot of cases um, far back, then and there's only like a few cases that may have just come out in a few years, then that's going to really skew the results you get. And so that's where I think the sort of the experience of an attorney is really going to have to come in, and the attorney is probably going to have to feed those types of cases and really guide it and that type of thing. And that's why these things cannot be used on their own because the historical patterns can really get in the way of those things and kind of obscure what's happened more recently. I hope that answered your question.
Thank you. Thank you, Judith. And I think we're up with today's session. I think it was a great discussion. Thank you so much for your time, especially with this trending and timely topic like the impact of AI on the legal field. I'll be sharing the slides that Judith presented today with all of the participants. My name is Barbara. I'm the Assistant Director of the Office of Graduate Programs. In case you have any questions, we do have some application deadlines coming in. I see some international attorneys, paralegals registered with us today. Thank you so much for your time. In case you're interested in starting a program with us, I'll be happy to answer any questions. Thank you so much, and we will be uploading this presentation to our website.
Thank you, everyone.
Thank you. Have
Have a
a
good
good
day.
night. Bye bye.